All right, everyone. Well, we've got actually a lot to cover today. I just wanted to get everything underway because we do have quite a bit, but I just wanted to say good morning, everyone. Thank you so much for tuning in to our webinar on Australian employment law updates. It is a long time coming since our last one. We did do it a few months ago, and there has definitely been a lot of changes in the space. My name is Sanam, and I'm Employment Counsel here at Employment Hero, and I am actually joined by the lovely Aahana Lakhia. She works as the practice leader at EI Legal. Aahana, if you'd like to give a little bit of information about yourself.
Thanks, Nam, and good morning, everyone. Thank you for joining. So as Sanam mentioned, I'm the practice leader at EI Legal. EI Legal is a specialist employment law firm. It's a sister company of Employment Innovations. Employment Innovations as a company supports businesses with a variety of outsourced HR, payroll and safety services with the overall aim to make employment easier for our clients and help them becoming more compliant. EI Legal as a law firm sits alongside Employment Innovations, and all our lawyers are experts in employment law. That's all we do. We provide bespoke and tailored advice in relation to complex workplace matters like restructures, tricky terminations, award entitlements, all sorts of things. And we frequently also represent clients in workplace disputes before the Commission and the federal courts. The other thing we do is we aim to keep our clients up to date with changes in the legal landscape, such as through our blogs, newsletters, and webinars. So if you think you need legal advice in relation to the updates that we discussed today, please feel free to reach out. One of our lawyers at EI Legal will be happy to have an initial discussion. Thanks, Anam.
Oh, perfect. Oh, no, thank you so much. And it's so valuable to have Aahana here today. She's mentioned, everybody's experts at EI Legal in terms of employment law. So it is great to have this asset today to get a good understanding of all of the different changes. Before we get stuck into it fully, I just want to do a little bit of housekeeping. So this is a Q&A session. It is being recorded, and because it is a Q&A session as well, I would say please leave your questions down below on your Zoom screens, and we'll try to get to as many questions as possible. If we don't get to your questions, then we will definitely endeavour to answer them after the webinar. But like I said, this is a recorded webinar, so please don't go frantically writing everything down. We will be providing this webinar recording along with the slides and some other information as well to all the participants. So in terms of getting stuck in, today we're going to be looking at specifically, three areas of change. So the first one is going to be around the secure jobs, better pay changes that have come in because of the update to the Fair Work Act, as well as looking at the changes to the sex discrimination legislation, and then a couple of other changes to paid parental leave, as well as the recent decision around working on public holidays. So before we fully get into it, I just also want to say that this is a lot of information to cover. So as you can imagine, each topic will require its own, webinar, and we've tried to keep it as high level and hitting the main points as possible. So absolutely, we have put in information in there that you can have a look at later on, and further, webinars and guides that you can definitely use. But in terms of the information covered today, we'll keep it as high level as possible. And before we get stuck in, one more thing, the disclaimer. So at the end of the day, this is provided as information to you all in good faith. We're here to give you a general idea and general guidance around where you can find some information, how to tackle these workplace problems. But if you are dealing with something specific to your workplace as an employer or an employee, I would say absolutely, there is nothing better than getting specified legal advice, and EI Legal is definitely there to help. So please feel free to reach out, and we'll also leave their contact details towards the end of the webinar as well. So I'll hand it over now to Aahana to get stuck in to the employment law updates relating to secure jobs and better pay.
Thanks, Nam. All right, look, as Sanam mentioned, there's a lot of content, so I'll try and keep it as concise as possible, but also get through as much as I can in the time we have. So in December of last year, of 2022, the federal government passed the Fair Work Legislation Amendment Secure Jobs Better Pay Act 2022. And for the purposes of our webinar today, I'm just going to refer to it as Secure Jobs Better Pay Act. Now, that piece of legislation amended the Fair Work Act to change a number of existing rules and introduce a range of new workplace laws. These are actually the most extensive changes to the Fair Work Act since its introduction back in 2010, and the impact is quite significant for employers. Now, all these new laws, they start on different dates. So what I'll do is I'll take you through the key changes. I'm not taking you through all of them, but just the key changes which we think would be beneficial for you to know, which are summarised on the slide. So the prohibition on pay secrecy clauses, the termination of zombie agreements, the limit on the use of fixed-term contracts, the expansion on requests for flexible work, and the prohibition of sexual harassment under the Fair Work Act. So let's get started with the first one. So employees now have a new workplace right under the Fair Work Act to choose whether or not they want to disclose their pay or any terms and conditions of their employment that determine their pay outcomes. So for that reason, because that workplace right exists under the Fair Work Act, for any pay secrecy clauses in existing employment contracts, they'll have no effect. And in any new employment contracts, those pay secrecy clauses are actually prohibited. So what employers need to do is to ensure that you review any existing contracts and policies to ensure that they don't contain any pay secrecy clauses, because if they do, they'll have zero effect. And just ensure that any sort of contracts and policies are actually updated in line with these changes. Now, this actually took effect back on the 7th of December 2022, so in effect now. So make sure that you review your contracts and policies, and also, just ensure that there's no sort of culture in the workplace where you're sort of prohibiting employees from discussing their pay, because it's now an explicit workplace right for them to do so under the Fair Work Act. So that's the first change. On to the next for that. Thank you. All right, the termination of zombie agreements. So zombie agreements are essentially enterprise agreements, which is an industrial instrument, or a collective agreement, which came into effect prior to the Fair Work Act, so prior to the 1st of January 2010. Any such enterprise agreement or collective agreement is it's referred to as a zombie agreement. Essentially what the change is now is that there's what's called an automatic sunset period for some zombie agreements. So from that sunset period is from the 7th of December 2022 until the 7th of December 2023 this year. Now, during that time, any employers who have a zombie agreement with their employees, they're required to take some steps. And the first of those steps is by the 6th of June this year. And that requires employers to write to employees to inform them that they're covered by a zombie agreement and that zombie agreement will be terminating automatically on the 7th of December this year, unless, of course, it's extended for a certain reason, but I won't get into that because, that, again, that will take too long. But essentially, employers are required to inform employees that, one, it will be terminated, the zombie agreement automatically, and once that's terminated, the relevant modern award will instead apply to the employees. So that's a step that needs to be, that employers need to take by the 6th of June. What we recommend you do is, if you are a business who has an enterprise agreement, double check whether it's a zombie agreement. And a zombie agreement, again, is one that came into effect prior to the 1st of January 2010. And if you do have a zombie agreement, seek advice regarding your notification requirements and next steps. And again, when does the change take effect? It will terminate on the 7th of December this year. All right, so that's the change of zombie agreements. Moving on to the next one. I appreciate this is a lot of information, so yeah, please feel free to put in all your questions in the chat box, and I'll do my best to answer at the end of the webinar. All right, so limitation on the use of fixed-term contracts. Now, this is only relevant to employers who actually use fixed-term contracts. Just briefly, fixed-term contracts are contracts that have an end date. So, for example, it will say, you know, you're employed for a specific project, and at the end of that project, your employment will automatically terminate. So it's for a fixed term. Or it will say you're employed for a fixed term from this date until, you know, another date. Now, there's limitations on the use of those contracts or those fixed term contracts or maximum term contracts. Maximum term contracts are basically fixed term contracts, but they have with an expiration date, but they have a general right, employers have a general right to terminate prior to that end date. Now, the changes basically say that employers can only enter into a fixed term contract for a term of 2 years, including any sort of renewal period for that fixed term. And those fixed term contracts, they cannot contain a right to keep extending or renewing that term more than once. So even if that period of contract is not more than 2 years, you can't have a provision in that fixed term contract which allows the employer to extend it for more than once. So that's quite a key change, because I have seen, you know, a few clients who sort of use fixed term contracts and keep issuing them over and over again to employees. So that is not allowed anymore. There are some exceptions to this, including where an employee is engaged to perform a distinct and identifiable task, using specialised skills, or performing essential work during a peak demand period, or work under a government funding arrangement. But again, that's only for a period of 2 years. So there's quite sort of strict rules about when fixed term contracts can be used. And the consequences of having an unlawful fixed term contract is that the employee will automatically be considered to be a permanent employee. So a permanent as in a full-time or a part-time employee. So employers won't then be able to rely on that expiration term to then just end the employment of that employee, and employees will have the right to notice of termination, redundancy, unfair dismissals, etc. So it's very important for employers who are using fixed term or maximum term contracts to review those contracts, audit the circumstances in which they're using them, consider actually offering permanent employment to those employees and issuing new contracts. Now, that change actually takes effect on the 7th of December this year, so 2023. So you have some time to review those contracts, but I strongly recommend for any employers using fixed-term contracts to take that time to audit those contracts and issue new contracts to employees. So that is something that I would recommend you obtain legal advice. So if you are doing that, please feel free to reach out. Okay, on to the next one. All right, so there's now an expansion on the request for flexible work, and also a request to extend a period of parental leave under the Fair Work Act. So there's a process now that employers must follow when they receive a request from an employee for flexible working arrangements. And it's a lot more prescriptive and it's more onerous on employers. So there's an expansion, firstly, on circumstances when employees may request flexible work, for example, and that includes where an employee or a member of their immediate family or household experiences family and domestic violence. So in those circumstances, an employee can actually make a request for flexible work. Once that request is actually made, employers are now required to, within 21 days, either approve that request or discuss that request with the employee and agree to those changes. Or if they're going to deny that request, they need to discuss those requests with the employee and clearly set out the reasonable business grounds on which they refuse that request. Now, key change now is that if an employer does set out why they've refused that request based on reasonable business grounds, an employee can now dispute that. They can challenge it. Previously, there was no such right. An employee can now challenge that request where it's been refused by the employer by making an application to the Fair Work Commission. So the Fair Work Commission can actually deal with a dispute of that kind. There's also similar requirements for the extension of parental leave for a further period of 12 months. As you may be aware, eligible employees are entitled to take a period of 12 months of unpaid parental leave. There's also a right under the Fair Work Act to seek an extension for a further 12-month period, and employers can deny that further 12-month extension on reasonable business grounds. However, there's now that extra requirement for them to clearly explain that in writing, and employees can now also dispute that with the Fair Work Commission where it's been refused by the employer. So what should employers do? I see a lot of employers have, parental leave policies which basically mirror the obligations under the Fair Work Act. So ensure that you review those current policies and procedures to ensure that they're meeting the obligations and the changes under the Fair Work Act for requests for flexible work and an extension of parental leave. That actually takes effect on the 7th of June 2023, so that's fast approaching. So if you've got those parental leave policies, ensure that you review and update them. And if you have any advice, again, if you require any advice, please feel free to reach out. Okay, so the most significant of the changes, in my view, to the Fair Work Act is a new express prohibition on sexual harassment in connection with work. So previously, where there was employees had issues with sexual harassment, they only had an avenue under the sex discrimination legislation to pursue or make a complaint in the Australian Human Rights Commission against an employer. There was nothing under the Fair Work Act in relation to sexual harassment. Now there's a new express prohibition of against sexual harassment in the Fair Work Act. Very briefly, the definition of sexual harassment is basically where a person makes an unwelcome, and the key word being unwelcome, sexual advance or an unwelcome request for sexual favours against another person, or the person engages in other unwelcome conduct of a sexual nature. And this is in circumstances where a reasonable person would anticipate that they're being harassed, or that a reasonable person would feel offended or intimidated by this conduct. So this new prohibition under the Fair Work Act, most importantly, it applies very broadly to workers and prospective workers. And it's not just employers, but also persons conducting a business or undertaking. And principals, such as employers, will be found vicariously liable for any acts of sexual harassment by their employees or agents, like contractors. So it's very important for employers, to ensure that they, have the correct policies in place to prevent such sexual harassment from occurring in the first place, because they could be held vicariously liable where any such conduct occurs. There's now also an ability for workers and unions to file an application in the Fair Work Commission in relation to any sexual harassment in the workplace. And this goes through a similar sort of conciliation process as any unfair dismissal or general protections claim in the Fair Work Commission. And importantly, this is actually a civil remedy provision. So if found liable, the penalty is $82,500 for a corporation and $16,500 for an individual who's involved in the contravention. So it's quite a significant change. What employers should do, because this is sort of an express prohibition, what you need to undertake, we strongly recommend undertaking an audit of the risks of sexual harassment in the workplace and implement effective policies and procedures to deal with these risks, because employers need to demonstrate that they've taken reasonable steps to prevent sexual harassment from occurring in the first place. And that includes having effective policies to deal with these things. So it's very important for employers of all shapes and sizes, no matter how many employees you have, to have these policies in place in relation to sexual harassment. When does the change take effect? Now, this express prohibition applies for sexual harassment which occurs on or after the 6th of March. So we're past that now. So any sexual harassment that's now occurs in the workplace on or after 6th of March 2023 this year is captured under this prohibition, under the Fair Work Act. Just remembering though, for any sexual harassment that occurred prior to the 6th of March 2023, there's still avenues for workers under the sex discrimination legislation. This is just in relation to the Fair Work Act. So yes, that's the final change. Those 5 things that I've sort of talked about, those are the key changes from the Secure Jobs Better Pay Act. But separate to that, there have also been recent changes to the sex discrimination legislation, which have stemmed from the Respect at Work report, which was released back in March 2020 by the Sex Discrimination Commissioner, Kate Jenkins. And that was following a national inquiry into sexual harassment in workplaces. So these changes introduce a new legal frameworks impacting employer obligations in how sexual harassment and sex discrimination is prevented and addressed under the sex discrimination legislation, so not the Fair Work Act. So I'll now hand over to Sanam to discuss these changes.
Thank you so much, Aahana. So absolutely right. These Aahana and I were actually speaking about this earlier today, and we were talking about the fact that you can see that there's been a tightening around sex discrimination and sexual harassment under a lot of different pieces of legislation, like the Fair Work Act, Sex Discrimination Act, and also Work Health and Safety as well. So, so we can definitely see that that's where the push has been in terms of this particular change. So now there is a positive duty to eliminate sex discrimination. To get a better understanding of the difference, Aahana went through what sexual harassment is. In terms of sex discrimination, to give a broad definition, and the slides will have a little bit more detail in them in the notes, but it is about discriminating against a person's sex, including their sexual orientation, gender identity, even marital status, pregnancy, potential pregnancy, breastfeeding, all of those factors. So it is really important to for employers now with this positive duty to really take a step back and have a look at their business. So the positive duty essentially, it says that an employer or a PCBU, a person undertaking a business, or being a PCBU, they need to have reasonable and proportionate measures to eliminate unlawful sex discrimination in the workplace. So that extends, as Aahana said, to sexual harassment and victimization as well. So the whole purpose behind this was to have an active, kind of approach to the situation, rather than looking at a reactive approach where only when a complaint is made or something is brought forward, that's when an employer will, look into it and investigate. So it allows for, proactivity on the employer's part, but I do understand that it adds a lot of pressure on these employers. And in terms of the reasonable and proportionate measures, the reasonableness will depend on company size, nature, and the circumstances of the business. So it isn't necessarily that, there is no proportionate measures or anything that smaller businesses will need to take. You will still need to take it, but the extent at which will depend on the circumstances of the business, the size of the business. Are they an SME that's a mum and pop business and they're just trying to run their day by day and they're trying to make best efforts to put these in place? So if you look at, the examples, and like I said, we've put some links in there to the information, you'll see the different scenarios that they have mentioned in the report. But in terms of who has power over this area, the Australian Human Rights Commission will have the powers to ensure that there's positive duty and that employers are complying with that positive duty. They can also issue compliance notices as well. But I think what's really important to look at here is that the Commission has mentioned that while this has come into effect on the 13th of December, they understand the lengths that employers will need to take to get things up and running in their workplace. So they have, provided some time for employers to get policies in place to make sure that they've done a proper risk assessment and really considered, what's happening in the workplace and how to prevent and actually eliminate sex discrimination. And the movement is towards December at the end of this year to have that up and running. And that's when the commissions will start, doing their compliance orders. So like I said, businesses have time. You have the opportunity to get things all sorted. And what employers should be doing here is to put measures in place in the workplace. So undertaking a risk assessment, having a look and seeing, is there particular areas of the business where, or particular issues in the business where there might be risk to sex discrimination. It's important to collect and monitor data as well. These are not requirements, but they're there to help you and assist you as being tools, and to provide support and training. I think from what Aahana's mentioned as well, and with the sex discrimination changes, what we can see is it's not just about training your management anymore. It's about providing support and education to all of your employees about how the company will deal with these situations, what policies they have in place, how they're going to the procedures that they will go through, and how things will be handled if anything like this comes up. So like I said, it is coming into effect, it already has come into effect on the 13th of December, but you do have a little bit of time now to get the business up and running, but I wouldn't take that as, we have a lot of time under our belt. I would definitely say, as much as this is an extra difficulty placed on employers, it is there to make sure that the workplace is a safe and healthy workplace for your employees, managers, everyone, suppliers, contractors. So I would definitely say have a look into this and start getting the business up to speed. And the next part of the Sex Discrimination Act that has actually changed as well is a new offence that's been mentioned in terms of a hostile work environment. This is a little bit different to sex discrimination, like I've defined it, and sexual harassment. Here we're looking at it being unlawful for a person to subject another person to a workplace environment which is hostile on the grounds of sex. So we're kind of looking at an offence being created here, which is not directed necessarily to a particular person, but it could be directed in the company to a lot of different people. So what we can look at is conduct that is offensive, it's intimidating, humiliating for people of one particular sex. And then also examples of this would be things like having an obscene poster on the wall, or maybe workplace banter or innuendo, which suggests that there is underlying sexist jokes or something along those lines. Now, the reasonable test will still apply for this as well, in terms of, how would a person reasonably feel in these circumstances when this has happened to them? Would it be offensive, intimidating, humiliating for that particular person? So similar to what is applied when you're looking at sexual harassment. In terms of what employers need to be doing, it goes a step beyond looking at your policies. I would say now is the time to be looking at your workplace culture as well. I'm sure Aahana has dealt with this many times. Workplace banter can be acceptable up until a point where an employee might take it too far, or the employer wants to finally put their foot down because somebody's complained. So it's really important to make sure that you set those boundaries from the beginning. It's much easier to reprimand by example and not have that in the workplace, rather than trying to do it on the back foot where it's already been happening and now you're trying to set these expectations. But that's not to say that it's too late. Absolutely, you can introduce these policies into the workplace and really reinforce the behaviors that employers should be doing, their managers should be doing, and employees should be doing, all those positive behaviors. And there are other options like implementing gender equality policies and other inclusivity strategies as well. So there are a lot of options to employers to make sure that the workplace is a safe workplace, and to make sure that employers at the forefront say that, no, this is not acceptable, and this is the position that the company takes. So again, this is in effect too. Now, as of the 13th of December last year, it's fully underway. So I would say while you're looking at, sexual harassment, sex discrimination, and other workplace health and safety regulations, I think it would be the time now, I'm sure Aahana agrees as well, to start going through your policies, actually putting in training support and taking it that extra step further. So the next change that's actually happened, and this falls outside of the previous pieces of legislation we discussed, is the changes to parental leave. So at present, the Parental Leave Act actually provides for a total of 18 weeks, funded parental leave for, eligible employees. The changes that will come into place a little bit later on, but it is fast approaching, is to provide for greater flexibility and eligibility to this particular scheme. Like I said, the existing 18 weeks that's there will now actually be combined with 2 weeks dad and partner pay to provide a single 20-week scheme. So that can be shared between each parent as well. And employees who are single will still, be able to access that full 20 weeks of parental leave, and employees will be able to receive parental leave in various blocks as well. So that's a bit of a change. So of at least a day at a time, up to 2 years from the birth of the child or their adoption. That provides a little bit more flexibility, as you can see, and that was the whole purpose behind this. Now, the test for eligibility is going to be amended, and it will be looking at $350,000 per annum as a family income test, which we've seen being quite different before. And now, in terms of what employers should be doing, it's definitely advisable to review and update the existing policies that you have in place, and look at any of those policies that are referring to that government-funded parental leave scheme. So, like I said, the changes have not taken place yet. They will be taking place on the 1st of July, but we're only a couple of months away. So definitely have a look at that. And but I would say probably the sex discrimination and the Fair Work Act changes is probably at the forefront. But please get around to this as well. And the last change that we'll discuss is something that's happened relatively recently, and it's not necessarily a legislative change. It is actually based off of a recent federal court case. And in this case, it was, as you can see, construction, forestry, maritime, it dealt with that industry. And the federal court case looked at basically the dissection of section 114 of the Fair Work Act. So we're looking at whether employers are able to request an employee to work on a public holiday, and specifically whether an employee can actually say, no, I don't actually want to work on the public holiday, and whether an employer can say, well, you've got to do that. So in this particular case, there were a lot of, I guess what it focused on was around the fact that these employees in their general pattern of work would normally work on Christmas Day and Boxing Day. And that was part of the employer's usual rostering arrangements. And because of that, the employer had asked them to work on a public holiday, Christmas Day and Boxing Day. And there was no specific request made to the employees. So it was, there wasn't a question posed around, can you work, or, this is coming up, I'd like your feedback or anything like that. It was, as had been interpreted in the past, that it was more of a direction. Now, the federal court found that employers can only require employees to work on public holidays where they have first requested the employees to work. So this whole idea of requesting the employee, I mean, there is now no ability to simply require an employee to work because the business is operating during that time. There is now a compulsory step around that requesting. So it's about first asking the employee, whether they can work, or however you would do your normal rostering system, to send it out as a potential draft form, rather than saying that this is the hard or fast roster and this is what we're going with. And then from there to get the employee's feedback and confirmation that they will be working. Now, that's not to say that an employee can refuse and that's it, and then they just walk away. There is definitely options for the employer. where there isn't reasonable grounds for the employee to refuse. Some of these extend to the nature of the business, whether it was expected that the employee would normally have worked during that time, and also the type of employee they are, whether they're casual, part-time, full-time, and also other factors like if they were going to receive overtime payments or penalty rates or different things like that. So I've listed those in the slides as well in the notes section. So absolutely feel free to have a look. We also have a link to the case in there as well. But for the purposes of this, the court did find that that employees are able to refuse, but obviously on reasonable grounds, and that the request needs to be made. And what I would say now is that employers definitely need to look at their employment contracts. They need to see what the wording is around public holidays. It cannot be a direction coming from the employer anymore. It has to be that request, and the employees need to be given that ability to accept or deny working the public holiday. So this is fully taken effect now. Like I said, it's not a piece of legislation, and so I would definitely say to go and have a look at any of the documents that you have around public holidays and working on public holidays. All right, perfect. Well, I think that brings us into the Q&A segment that we've got here. Aahana, was there anything else that you wanted to add to any bits that we discussed?
No, not necessarily. I have been reviewing the questions as they've been coming in. I've tried to answer as many as I can within the chat box. But there's a bit of a theme to some of the questions, so I might address a few of them, and then so now I'll hand it back to you. There's quite a lot of questions on the exceptions to the limitation on the use of fixed-term contracts, and there's specific questions in the Q&A box. As Sanam mentioned at the beginning, we can't necessarily provide you with specific advice during this webinar, but I should note that these are very new changes. They're yet to come into effect, as you know. It will be on the 7th of December this year. And the exceptions to the limitations, they haven't yet, there's quite a few, and they're quite complicated, and they haven't yet been tested. So if you do have a specific question, I can see a lot of questions about government-funded fixed-term contracts. I would strongly recommend that you do seek legal advice, because it isn't like just, the limitation's not just sort of a hard limitation. There are a number of exceptions to those limitations, and it's not just what I stated on the slide. So if you're using fixed-term contracts, I would definitely recommend getting some legal advice. There was one thing that I failed to mention, is that similar to an employer's obligation to issue a Fair Work information statement when hiring a new employee, and a casual information statement when hiring a casual employee, that the Fair Work Ombudsman will now also be preparing a fixed-term employee information statement. So for any fixed-term contracts or fixed-term employees, there will be an obligation to issue that statement as well to employees. So just again, going through some of the questions. Someone asked a very good question of what would reasonable business grounds include? And I'm assuming that is in reference to that expansion in relation to the request for flexible work or the request for an extension of taking parental leave. Now, that's actually defined under the Fair Work Act. So the Fair Work Act clearly outlines what reasonable business grounds are, which, for example, and I'll read some of them out, include that these new flexible working arrangements would be too costly for the employer, that the employer doesn't have the capacity to change the working arrangements of other employees to accommodate the new working or proposed working arrangements of the employee, that it would be impractical to change the working arrangements or to recruit new employees to accommodate the proposed sort of flexible working arrangement, that the new arrangements would likely result in significant loss in efficiency or productivity for other employees or the business as a whole, or that it would significantly, there'd be a significant negative impact on customer service by implementing this flexible work approach. Now, it's not going to be sufficient for employers to simply point to one of those exceptions and say, oh, it's because of that. They need to really demonstrate why they're relying on that exception. So, for example, say an employer denies a request for flexible work on the basis that it's going to be too costly for the employer. Well, they then need to sit down with the employee to really provide examples as to why it would be too costly. Because if they simply just say it's too costly, and the employee then now they have the right and the ability to dispute that, including by filing an application to the Fair Work Commission, it will then be on the employer to demonstrate, well, why is it too costly? So those are just some examples of what reasonable business grounds include. So I hope that answers that question.
Well, I was going to say, Aahana, I saw some questions around the harassment piece and sexual harassment, and one of them was around the training that would be recommended with the changes, and I would say that most likely it goes a little bit beyond the training as well. While you will be maybe doing, maybe you can do a meeting, a webinar or something with the employees to understand the policies a little bit better once you've introduced them. It would also extend to maybe doing, when you do your, weekly meetings, to just check in with the employees to say, hey, is there anything that's happening? Do you want to flag anything? And even into in one-to-ones as well. So I know this person particularly asked if a 5-minute kind of online video would be sufficient, and it would be more so about whether you're covering all of the bases. And I would say definitely look at the links that we've put in there around what the threshold needs to be for businesses. But I'd love to hear, Aahana, if you've got any suggestion.
Of course. Yeah, look, that's a great question. And I think it also helps answer another question. Someone's asked, what is the definition of positive duty? Now, that positive duty is under the Sex Discrimination Act. It's under Section 47 C. And it basically says that the positive duty on employers is to take reasonable and proportionate measures to eliminate unlawful sex discrimination, sexual harassment, and victimization. So what are reasonable and proportionate measures? That's going to depend on a number of things, including the size, the nature, and circumstances of the business or undertaking, that duty holder's resources, whether financial or otherwise. For example, do they have a HR department? And also the costs associated with taking those positive steps. Very helpfully, and although these haven't been included in the slides, the explanatory memorandum to the Respect at Work amendments, it actually outlines examples of what employers can do to meet this positive duty. And as I mentioned, it depends on the size, nature, and circumstances of the business. So whether you're meeting the positive duty will really depend on your business. And this explanatory memorandum outlines and provides specific examples for small businesses, medium-sized businesses, and large corporations. And very briefly, for example, for a small business, given the nature of that business, they can write a short policy on sexual harassment and discrimination. They can discuss that policy during a staff meeting, make sure all employees have a copy of that policy, and regularly check in and staff to discuss any behavioural issues or concerns. So for a very small business, that is likely to meet that obligation. Whereas for example, a large corporation, you probably need a lot more. For example, you need a strategic plan on tackling and preventing harassment and discrimination, including sort of confidential staff surveys, data collection, regular reviews of policies and procedures, and mandatory training for managers and new staff on harassment and discrimination. So sometimes also what's a relevant consideration is today there's a lot of remote workplaces. So there's also going to be different sort of requirements on remote workplaces to meet that positive duty. And for example, you could develop and circulate specific guidance on harassment and discrimination in a remote context. So, and what sort of support is available to staff. So, for example, having policies which, clearly outline, sexual harassment or discrimination can also occur online through, for example, emails or whatever messenger services you use like Slack. So it's really going to depend on your business. But I hope that sort of answers the question about positive duty.
And I think also somebody's asked around, whether they can include all of these changes into their current discrimination, bullying and harassment policy, or should they separate it out? And I would say it now with sexual harassment, being quite in depth in terms of the requirements and the procedures, which would be slightly different potentially from having a complaint raised about maybe bullying or some sex discrimination. I would say that it's definitely worthwhile to look at splitting them out, but it solely depends on the workplace. Some workplaces have them all together, but I think now with the kind of the significant changes that have happened, it's probably worthwhile. But Aahana, if you've got any suggestions around having it as one cohesive document.
Yeah, look, I can see there's quite a lot of sort of questions around it. It doesn't necessarily matter whether you have one policy or several different policies, as long as you're addressing what you need to address. So for example, a lot of employers have a anti-discrimination, sexual harassment, and sort of bullying policy all in one, which is fine. Or you can have an anti-discrimination an EEO policy and a separate one on sexual harassment. But what is really important is that they do now outline specifically that employers have a duty, a positive duty to eliminate sexual harassment in the workplace. And also, most importantly, and I think this is answering someone else's question, the policy is updated to include this new prohibition regarding hostile environment. So it needs to outline, what is a hostile work environment on the grounds of sex, and it should include examples of what would constitute a hostile work environment, so that employees and workers are sort of educated and understand what it is. And if a claim is made, then employers can demonstrate that they have taken reasonable steps by implementing a policy and educating their staff in relation to these provisions under the legislation. I hope that answers that. Sam, I'm not sure if you've had a chance to review any of the other questions, but I'm going through the chat box. So if you want to have a go at any other questions, I'll try and find one I can answer.
Sure, no, absolutely. We do have a lot of questions around any kind of general advice around, providing support and training for these, sex discrimination, sexual harassment changes. I would say that it's something that we can definitely provide more information on anybody that will be providing this training, or any, ideas of partners that we work with. I don't know if EI Legal specifically, provides this service, but definitely an option. Oh, perfect. That's good to know.
Yes, we definitely can provide specific training on sexual harassment and sex discrimination, and we're also in the process of developing, and I think someone else has asked this question, a risk assessment tool that employers can use. So please do reach out if that's something that you're interested in. We can certainly help with that.
Oh, perfect. Oh, no, that's brilliant. So I think definitely a lot of people have asked around that. So absolutely, like I said earlier in the webinar, there is no better advice than specific tailored advice to your situation. As much as it can seem the same, no two employment matters are ever the same. There'll always be slightly, some differences in the facts. But other than that, just looking at kind of the questions around public holidays. So I did see a couple of questions around, refusing public holidays and what the employer needs to have a look at to make the employee, say that they need to work. I would, again, go back to the points of you need to have a look at the nature of your business, the kind of work that's being undertaken, what the responsibilities of the employee are, also the employee's personal circumstances. Do they have any family commitments or responsibilities? Are they taking off that time to do something in particular, or what's the circumstances around that, as well as looking at would the employee have normally worked, or would there have been an expectation for them to work? So there is a list of information, and that will be in the webinar slides as well, and we will be sending those out after the presentation is done today. All right, and I could see some questions around fixed term kind of contracts applying to contractors, and that wouldn't be the case in this situation. They sit very separately to an employee, and they would be engaged to provide a service. So that would not fall in line with these fixed term arrangements. Would be usually project-based work, or for a set time, depending on covering parental leave and things like that, which would be quite different to an independent contractor.
That's right. Sorry, Sanam, I've seen some questions about pay secrecy and updating the contracts. Now, there's some questions in there which say, do you have to issue a brand new contract, or can you issue a letter of variation to the contract? Look, our advice in relation to that would be, obviously, it would be ideal to issue a new contract, because given all the recent changes, it's a good time to review your contract to ensure it's up to date. But, if you're quite positive that everything's, in line with current legislation, other than the provision on pay secrecy, you can issue a letter of variation to say, look, as you know, due to recent changes, you now have a workplace right about whether or not to disclose your pay. And so any provision in your existing employment contract, which refers to pay secrecy, no longer has any effect, but the remainder of the terms and conditions of your employment contract continue to apply. So you can issue that again. However, I would recommend, if you do want to do that you seek specific legal advice to draft that letter of variation, and also just to double check that your contract as a whole is up to date. So I hope that answers that question.
I can see some questions around the public holidays, or working on public holidays, and around employment agreements currently saying that an employee will be required to work whether on a public holiday as part of that rotating roster. The question is actually quite specific, and it is quite similar to the case that I had discussed. So in those situations, that's where you would go back and have a look at your employment contracts and really look at the wording, and we're looking for things like, the employer may request the employee to work on these particular days. So we're really trying to stay away from the employee will be required to work on public holidays, because it has to be that request element that's come up. All right, we'll just go through and see. I know that we've got about 7 minutes left or so. So I'll just see if we've got anything else that's come up quite often.
There's questions about fixed term contracts. I've seen a few where they've been asked, which say, what if the employee insists or requests the fixed term contract? Or there was a question about what if it's a common law contract that has been negotiated. Look, basically, this legislation, it's under the Fair Work Act. It's irrelevant whether it's been negotiated between the parties, between the employer and the employee, or the employee has specifically requested or insists on it. It's just not going to be lawful to have a fixed term contract which is longer than 2 years, or have a fixed term contract which contains a renewal, which is a renewal option for more than once. So the Fair Work Act, or the provision of the Fair Work Act, will basically supersede any sort of arrangement or negotiation or sort of agreement between the parties. So it is really important for all employers with fixed term contracts to review it. I think when actually bringing this when these changes were being discussed, according to the Minister for Industrial Relations, when they were discussing regulating fixed term contracts, more than half of employees engaged in fixed term contracts, so just sort of some stats, more than 40% of fixed term employees have been with their employer for more than 2 years. So I think that was one of the key reasons for this change. So if 40% of fixed term employees have been with their employer for 2 or more years, then they're more likely to be a permanent employee. So it's really important for those employers to review those contracts and convert those employees to permanent employment. And following on from that, there was a question about, again, just issuing a letter of variation when you want to sort of, move them to permanent employment. In those circumstances, I don't think it would be appropriate. It would be, you would need to issue a new full-time or part-time employment contract. to that fixed term employee.
And I can see here, going back to sexual harassment and the sex discrimination piece, a question around the duty of boards. I'm guessing that there'll be a board that will sit within the company. I believe that the liability still will extend to specific employees as well as the board employers. So in terms of making sure that you have this positive duty to do what's correct in the workplace and to have proper procedures and everything in place. So I don't think anybody can evade the changes, unfortunately. So so definitely I would extend that far as well. All right.
I think we may have time for one more. So question, and although it's not necessarily relevant to what's been discussed today, it says, what if they have been hired as casuals for more than 2 years? And I do want to sort of point out, fixed-term employment is different to casual employment. So the nature of casual employment is that it's irregular. There's no certainty of ongoing employment. You offer a casual employee a shift, they can either accept or deny it, and that can go on for a certain period of time. Fixed-term employment is where and it's usually either on a full-time or part-time basis that fixed-term employment is offered, but it's for a specific period of time with a clear expiration date. So it will be, at the end of a project or the end of a certain period of time. So that's different to casual employment. But if you do have casual employees who have been with you for more than 2 years, just generally be aware that under the Fair Work Act, casual employees who've been employed for 12 months on a regular and systematic basis can actually make a request to convert to permanent full-time or part-time employment. So that's something to be mindful of. Then there's other sort of requirements in terms of when that, what employers need to do with that request and in what circumstances in which those can be denied. So hopefully that answers that question.
Perfect. And one more question that's come up. It's a very brief one. It's around how soon things need to be updated and when around these particular changes. I would say that it's really important to stick to the specific dates that they've come into effect. And if you can front foot it and be ahead of the change, then that will set the business up a lot better. So that when you're, if anything comes up in the workplace, you're not on the back foot trying to navigate the new changes, as well as an employee complaint or any of the other changes that we've discussed today. So absolutely, try to implement it as soon as possible. And if before the change, then that's always better. But yeah, it's always good to just set yourself up right from the get-go. So
yeah. I'll just add to that. I know quite a few people have come on late and said, will you please share these slides? We will be sharing the slides, absolutely. But on the slides, the key changes that we've discussed, we've made it quite clear when the changes come into effect. So please feel free to go back and look at when the changes have come into effect. Some have already come into effect. Some you'll have a little bit of time. So have a look and be proactive, as Sanam has mentioned. But hopefully our slides will give you the answer in relation to when they can come into effect.
No, definitely. And we'll also be including the explanatory memorandum as well, that will have those examples in there and really clearly lay out, what's expected depending on the size of business, type of employer. So that kind of leads to the conclusion of today. Thank you so much, Aahana, for being here. Like I said, and as you guys would have noticed, world of wisdom. So thank you so much for bringing all of that expertise. And like Aahana mentioned as well, if you are looking for training, I know a lot of questions were around that. Absolutely, EI Legal is there to help you. And same with Employment Hero, we're there if you need any assistance with payroll or HR in terms of having a software to streamline everything for yourself and your business. And like I said, this will be recorded. It has been recorded, and we will be providing all of the slides and the information as well. So at the end of this presentation, we will have a pop-up that will be kind of a survey about this webinar. Please feel free to fill that in. We really appreciate it because it does provide us with feedback on what we need to change or what you actually liked. and it's definitely useful. So thank you so much, Aahana. I really
appreciate it. Thank you, Sanam. No, it was great, and thanks everyone for tuning in.
Yeah, no, it's lovely. And have a great day, everybody.